Good afternoon and welcome to the March installment of In the Boardroom. I'm Andy Phillips with Attolles Law, and hiding behind the dark screen is a sick Sarah Diedrich Kasdorf. So she has asked me to do introductions, which is always dangerous. This session today is going to deal with some advanced issues under the Open Meetings Law and Public Records Law. It's a bit of a deeper dive into some concerns and issues that I've seen recently with counties. And again, just like every In the Boardroom, I'm hoping that we have a solid back and forth discussion where we can address some of the topics that we're all grappling with, I think, in recent months and years under the Public Records Law and Open Meetings Law. As a reminder, to engage in that discussion, there is a chat feature and a Q&A feature in this discussion where the buttons on your screen, tap on chat and type your question, tap on Q&A, type your question. We'll get to those as soon as we can. A couple of housekeeping items. This webinar is being recorded, and so it will be available on wicounties.org. Once we are done and once the recording has had an opportunity to process, it'll be posted to the website, as will the slide deck from the discussion as well. So without further ado, and you'll notice on the title screen, it says Rebecca Roker. She's my partner, and she is in sunny Florida with her family. And I said, don't worry about dialing in today. I can handle it here. I will slog through the cold weather and wind and rain that we've got here in Wisconsin and have a discussion with you all today. So no Rebecca Roker, even though the title screen says she's going to be here. So without further ado, let's do a little bit of discussing public records law and open meetings law. We're going to start with some basics because foundationally, if we understand the foundation of the open meetings law and of the public records law, I think you can have an understanding of why it is that I, Rebecca, corporation counsel, other lawyers struggle at times in trying to deal with questions that arise under the public records law and open meetings law. So it's important that we have that foundational understanding to set the stage for the discussion that we'll engage in on some of these advanced topics. So with public records, we have concerns surrounding personal emails, personal messages, things of that nature that occur because oftentimes, especially with technology, there's a blurring between somebody's professional life and somebody's personal life. And when there's blurring like that, and we have to deal with something like the public records law, where's the dividing line between records that are personal and don't have to be disclosed and records that relate to an official's business that do have to be disclosed? We'll talk about that. With social media comes certain challenges. Social media is a fantastic way to get a message out to a very broad audience very quickly. With that comes danger because social media, there's no exception in the public records law for social media. And so we have to evaluate social media utilization and the records and information that is created as a result of utilizing social media under the public records law and make a determination as to whether that information records, are they disclosable under the public records law? Then, of course, we have all the costs associated with the storage of electronic records. We live in an age where we can generate records instantaneously, and we generate a lot of records instantaneously. It costs money to keep those records on a system. And so how do we address that? And then with open meetings, we're going to talk about walking quorum issues and closed session questions that we've seen arise. So again, we'll get to these points. Those 5 points are not intended to be exclusive. If you have questions or want to make comment about any of these items or anything else, please use the Q&A button or the chat feature contained within your screen. So let's start with, again, the basics. When we look at the public records law, we have this whole presumption of transparency. And I like the quote at the bottom, that's from the Erpenbach case. Transparency and oversight are essential to honest, ethical governance. And so understand that whenever we are going to claim that something is not a public record, when we are going to claim that that record is exempt from disclosure, when we are going to redact a record, whatever the case may be. In other words, we are telling somebody who requests public records no, or at least partially no, that we are, if challenged, going to go to court, and the very first thing that a judge is going to read is 19.31 of the statutes, which offers this presumption of transparency. So it's very difficult for us as lawyers representing county government to have an argument with the court about, even though the law presumes transparency, you should recognize the lack of transparency in this circumstance because of XYZ. So we go into court, I like to say, with one hand tied behind our back because of this presumption of transparency. Now, a lot of people view the presumption of transparency as a burden. I like to think of it as an opportunity. It's our opportunity as county government to show the public that we do things in an ethical and honest fashion. And we also view our obligations under the public records law as equally as important as any of our other obligations under the law. And so if we have discussions with our staff, with our employees, with our officials within the county about the importance of this presumption of transparency, let's begin with the proposition that one of our very important functions is to make sure that we comply with the public records law and allow ourselves or actually have a system in place to make sure that the public has access to the records to which they are entitled. And I would stress that in discussions with staff and discussions with other officials, that this is a very important duty that we have as public officials or public employees. Courts interpret the public records law in light of that policy declaration. That's right there in that Wisconsin Supreme Court case. And so, like I said before, every time we go into court, the very first thing that judge is going to read is that policy statement providing for transparency. Again, the purpose is to shed light on the workings of government. The goal is to provide access to records that assist the public in becoming an informed electorate. So then we get into the weeds a little bit on the public records law. Of course, we have a public records law. We do not have a public information law. The public is not entitled to ask questions and receive answers to those questions. The public is entitled to request access to and copies of public records. And so the definition of record becomes very important here. So when we look at the definition of record, number one, a record is something that must be created or kept in connection with the official purpose or function of the agency. And it includes, again, if there's a connection with the official purpose or function of the agency, any material on which written, drawn, printed, spoken, visual, or electromagnetic information or electronically generated or stored data is recorded or preserved, regardless of physical form or characteristics, that is kept by an authority. And an authority has a specific definition in 19.32 as well. Courts have said many times, it doesn't matter where a particular piece of information is stored. That doesn't matter. If the information qualifies as a record under the definition, it is going to be subject to disclosure under the public records law. And so we see that in the definition of record, there are certain inclusions: handwritten, typed, or printed documents, maps and charts, electronic records and communications, and in some circumstances, even our contractors' records. So even though we hire somebody to do something for the county, there may be access to that contractor's records in limited circumstances because that contractor is fulfilling an obligation that was imposed upon the contractor through an official function of the county. All right. I don't want to go down that road too far on the contractor record issue, but just understand that, again, this law is interpreted in a very broad fashion to promote transparency in government operations. So when we look at that definition of record, emails sent or received on an authority's, on the county's computer system is a record. That includes personal email that's sent by officers or employees of the county. And so if you have emails that are on the county system, they fit the definition of record. I'll talk in a moment when we get into some of the discussions about the separation between professional life and personal life, why some of those records might not be disclosable, but understand that an email created on the county system is a record. Email conducting county business, even if it's off of the county's computer system, is also a record. Again, remember what the court said. It doesn't matter where the stuff is kept, the medium on which it's stored or preserved. What matters is that it is a county-related email. So even if you send it off of your personal phone, you send it from your computer at home, doesn't matter. If it relates to county business, that's a record. But understand too, that not everything that a public official or employee creates is a public record. There is such a thing as a public official or a public employee having a personal life, and courts have recognized that. Where that line is drawn gets a little bit difficult to interpret in certain circumstances. We'll get into that discussion in a bit. So it's not a record. There is, in the definition of record, a statement about what is not a record. Drafts, notes, preliminary documents prepared for the originator's personal use or by the originator in the name of a person for whom the originator is working are excluded from the definition of record. And so what I like to think about is, say you're in a committee meeting. Say I'm on the county board, I'm in a committee meeting. The committee meeting is going on, and as the committee meeting is going on, I'm jotting down notes, handwritten, so that I can later refresh my recollection of what happened in that meeting. Those handwritten notes are not a record. Those are my personal notes. But as soon as I take those notes and I send them around to other members of the committee to verify something happened or did not happen, whatever the reason, as soon as I distribute them, it's likely that they become a record. So again, the focus is on personal use, prepared for the originator's personal use, okay? That's a narrow exception, and it requires careful analysis before we rely upon that exception, which brings up a good point. Whenever we're getting into these issues as it relates to records requests, make sure you work with corporation counsel. Make sure that you have an understanding of how these various exceptions work. And it shouldn't be your job as a public official or employee to make judgment determinations as to whether something is or is not going to be disclosed. Some of these involve rather complex legal analysis. And anytime you have complex legal analysis, immediately you should have a conversation with corporation counsel. Corporation counsel does an incredible job at understanding the public records law, for that meaning the open meetings law and many other laws, but they are incredibly well versed in all of these exceptions and all of these issues. So make sure you consult with corporation counsel. Another example of an exception from the definition of a record are materials that are available for sale or at the library. So just because you keep the Encyclopedia Britannica in your office and it technically fits the definition of a record kept by an authority doesn't mean that you have to produce a photocopy of the Encyclopedia Britannica if that Encyclopedia Britannica is available at the library or for sale through a third-party source. So again, that's one of the exceptions to the definition of a record. What is not a record, as I mentioned before, purely personal property of the custodian and have no relation to the office, and there's an important and in this, and evince no violation of law or policy, okay? So again, if we're talking about purely personal record, having nothing to do with your office or with your status as an employee, and if that purely personal record evinces no violation of law or policy, that is going to be excluded from the definition of a record. For example, personal email sent or received on an authority's computer is a record, but if it's a purely personal email, you don't have to disclose it. It's not a balancing test issue, but it is an exclusion from the public records law. All right, so before I move on to open meetings law basics, perhaps I'll turn to a couple of questions that we have here. Question from Jennifer: if you've used your personal device for county business in the past, is your device still subject to a public records search always? Or if you stop using it for those purposes, does that remove future searches? Remember that a public records requester has no right to search your personal computer or your personal phone. And for that matter, the requester has no right to search a county computer or county phone for public records. The requester simply makes a request. You have an obligation to respond to that request. If your personal computer or personal phone has a record that is subject to disclosure, you're going to have to disclose that record, not your computer, not your phone, but you have to disclose that record. And so if you had a personal device that contained public records, work with your IT department to create a backup of those records off of that phone before you dispose of that phone, or off of your computer device before you dispose of that computer device. I like to think that counties are going to think ahead, be proactive, and create a policy relating to the retention of public records and storage of public records, and that we have an expectation that all employees and officials within the county are going to follow that retention policy. That retention policy serves a couple of purposes. Number one, it reminds people of their obligation under the public records law to retain these records that may be subject to disclosure down the line. It ensures that the material, the records that we back up and we preserve, are going to be retained for the statutorily required period before destruction. But then also, if we get into court, and let's say we have a dispute and somehow a particular record was destroyed, if we have a policy on the books that says this is what you have to do, to me, as a lawyer, that looks a lot better than simply going to court and saying, Judge, I don't know what happened. Yeah, we knew that Supervisor Phillips over here was keeping all of this county-related business on his phone, but when he got a new phone and he wiped the old phone clean, so I guess some stuff was destroyed. Don't know what to tell you. That's not a very good legal position to be in. So I encourage counties to be proactive in thinking about potential opportunities for policies that address retention of those records, backup, storage, and so on. All right, we have another question here from Lynn up in Sawyer County. I know I can ask for prepayment for costs incurred over $50, but can I ask for the amounts less than that to begin completing the work and then send when done? Payment may or may not be forthcoming, I suppose. Yes, and I don't get into in this discussion all of the various issues that we encounter as it relates to prepayment of fees and charging fees. But again, I encourage people to reach out to the requester to give them advance notice of what the fees are going to be in the expectation that payment is forthcoming before the records are released. So let's take an extreme example. It doesn't hit $50, so we can't demand prepayment before we start fulfilling the request. But is there anything in the law that says we can't let the requester know that it's going to be $49 and that we expect payment before the records, we demand payment before the records are released? There's nothing in the law prohibiting us from having that communication. And to me, it would make sense to send the requester an email or communication that says, hey, when you come to pick up these records, it's going to be $49, because they may say at that point, oh, $49, I didn't realize it was going to be that much. Forget it. I don't want that. So have that discussion. So even though there are those statutory thresholds where we can demand prepayment when we hit the $50 threshold, or we don't have to fill the request, even if it's, $30, $40, whatever, have that discussion with the requester in advance to set that expectation. Yeah, Lynn says she just got a request from someone wanting information from 1913 board minutes for historical research. It's going to take about an hour of Lynn's time to manually review the old paper records to see when the individual was on the board and when he served as chair. I don't think that's Chair Schumann. He doesn't go back that far. So it's probably somebody else. And Lynn says that hour doesn't reach the $50 mark. Again, I think that if you have a discussion through email, perhaps, Lynn, with that requester to say, hey, look, here's how much it's going to cost you to get this record. You still want me to go through with it? There's nothing in the law saying that you can't have that discussion. Question from Mark. What about employee investigations, taking notes of conversations which may lead to a determination of if further action is warranted? Employees often want to maintain confidentiality. Would this be a balancing test issue? Would the Monfils law be any protection of confidentiality? Okay, you've asked me, Mark, a whole host of questions that raise legal concern about employee investigations, the balancing test, attorney-client privilege, potentially, attorney work product, and other issues. I'm not going to get into that today, Mark, but you raised some very good points that I want you to talk to your corporation counsel about, because there are a lot of exceptions that, depending upon the circumstances, are going to apply to your situation. And so personal notes that you take relative to discussions surrounding an investigation, first off, if they're personal notes, they are going to be exempt from disclosure on the public records law. But, just because they're exempt from disclosure under the public records law does not make them exempt from discovery in the event that a lawsuit is filed. So you need to be very careful about the information that you retain, because just because you've got a clean path forward saying that this record is not going to be produced in a records request does not mean that that record is exempt from discovery. So I'd be very careful about that. All right. Again, let's talk about the basics with the open meetings law, because you'll see some similarities here between the open meetings law and the public records law in terms of the policy behind open meetings law. Right there in section 19.81 of the statutes. And the purpose, of course, is to give the public the fullest and most complete information concerning the affairs of government. Liberal construction. What does that mean? Don't think of liberal, conservative, Republican, Democrat. That's not what it means. Liberal means a very, very open interpretation favoring transparency in government. Sound familiar? It's exactly the situation we've got with public records law. And so anytime we want to avoid application of the open meetings law, understand that if challenged, we're going into court with one hand tied behind our back. So be very careful about invoking exemptions to the open meetings law. Here's the key point. The open meetings law applies to every, quote, meeting of a, quote, governmental body. Meeting and governmental body are two terms that are defined within statute, and those are the important triggers to application of the open meetings law. And so when we look at the definition of governmental bodies, what it boils down to is that if there is something official creating an entity, it doesn't matter what you call it, ad hoc committee, task force, special advisory council, Jedi council, doesn't matter what you call it. If it was created by some sort of official action, it is likely going to fit the definition of governmental body under 19.82 sub 1. And again, there's been a lot of litigation surrounding this whole definition of governmental body, but all of that litigation has focused at the outset upon this issue with transparency. So what's going to promote transparency? What is going to lead to liberal construction? The courts are going to find more times than not that an entity, if there's some sort of official action creating it, that it's going to be a governmental body. This was the entire issue in the Krieger versus Appleton School District case from about 6-7 years ago, where the Supreme Court found that the school board in Appleton, even though it did not take official action, it had policies that suggested the formation of a committee might be appropriate in certain circumstances. And because staff followed that policy in the creation of a staff-only committee, that staff-only committee was subject to the open meetings law. So again, you have to be very careful about that. 1982 sub 2 defines meetings. And I like to think of it as the 2 P's test. That's in the Showers case. People and purpose. If we have enough people present to constitute a quorum or negative quorum or some other number of people to effectuate the outcome of a matter of business that is going to be before the county board or a committee of the county board, then we have enough people to meet the Showers test for meetings. But those people also have to be convened for the purpose of conducting governmental business. Just because you have a quorum of the finance committee gather in somebody's basement to watch the Packer game doesn't mean that you've got a meeting, because they're not convening for the purpose of discussing governmental business. But as soon as the halftime conversation turns into what you ought to do with the proposed amendment to the county budget, you got a problem, all right? So again, remember the 2 Ps when it comes to determining whether we have sufficient number of people and sufficient nexus between those people and the governmental business in order to fit the definition of a meeting. All right, so let's talk about some of the special considerations that we're dealing with here. First, under the public records law. Again, I'm going to focus on this purely personal issue simply because it is an issue that I've seen crop up more and more. I've seen it crop up more and more with the advent of technology. It's easy to send a text message. It's easy to post something to social media. It's easy to send an email. Every single one of those things that is quote unquote easy has the ability to generate records that may be subject to disclosure. And so the public understands that as human beings, we on the county side, whether we're employees or officials, are going to do what's easy. And so the public understands that the public records law can be used as a weapon to try to get information that 30 years ago, frankly, wasn't even there. And so what I have seen, and I think what a lot of corporation counsel have seen, what I'm frustrated about, I think what a lot of corporation counsel are frustrated about, is the weaponization of the public records law. All of a sudden, we're getting public records requests for every single email, text message, social media post that a particular official has made in the last 6 months. Oh my gosh, that's a ton of information. That's a ton of records. Do we have an obligation to respond to something like that? Because all they're doing is going fishing to find out what this public official may or may not have done in the last 6 months that is going to lead to embarrassment out in the public. You see a lot of these requests, especially around election time. And so it's entirely frustrating to see the weaponization of the public records law. Is there an exception in the public records law that says you don't have to produce records if you believe that the individual requester is weaponizing the public records law? No, no such exception exists. Instead, we are dealing with a law that was written long before any of these technologies existed, and we have to apply that law to technologies that exist today. So it's a process to go through and understand, and frankly, corporation, we're not the only ones that are struggling with this. The Attorney General's office struggles with this. Others struggle with this as well. But I will tell you too, incidentally, on the side here, anytime you go to the legislature and ask for an update to the public records law to address this, you're met with significant resistance. Nobody wants to touch the public records law or the open meetings law, because as soon as the legislature says, yes, let's take a look at this, then they're accused of trying to not fulfill on this whole public purpose of having transparency in government. And so it's very difficult to try to have these conversations with the legislature. And as a result, it's very difficult to apply a rather archaic law to current technological advancements. All right, so getting back to this whole question of purely personal. Again, remember, materials that are purely the personal property of the custodian and have no relation to his or her office that evince no violation of law or policy are exempt from disclosure under the public records law. Why do I have that whole part about evincing violation of law or policy in all caps? Because that's critically important. Here's my question. Who makes that determination that a particular email evinces no violation of law or policy? What I may think evinces no violation of law or policy has no bearing on whether it actually does evince a violation of law or policy. And by the same token, the requester may disagree with my determination. So who wins in that circumstance? Well, as we'll find out in just a moment, there may be a court case that makes that determination for you. That really doesn't do us a lot of good. And I say that because we get these requests in, we say that the information is purely personal, and so the remedy is to go to court and ask the court to figure it out. Well, what happens when you go to court? People hire lawyers, and lawyers cost money. So the county has to spend money on a lawyer to go to court to have this discussion about whether a particular email is purely personal and does not evince a violation of law or policy. The other side, the requester, is going to hire a lawyer too. And that lawyer is going to argue that that particular email does evince a violation of law or policy. And guess what? If the other side wins, if the judge agrees, guess what we have the wonderful, wonderful opportunity to do, and that's to pay the other side's lawyer. It's an expensive proposition. It's a time-consuming proposition. And again, it's a situation where the law hasn't necessarily kept up with these technological advancements. So again, understand that this whole exception for purely personal emails, it's a difficult one to apply depending upon the circumstances. And so we have to be very careful in doing it, which means have a lot of conversations with the corporation counsel about these requests when they come in, if we're going to rely upon that particular exemption. So again, purely personal. Materials purely personal property and having no relation to his or her office. Again, it's still a record, but disclosure is not going to be required. What are some examples? Emails with family news, your grocery list, communication with friends or family that don't relate to official duties. I think everybody would agree that those are purely personal emails. Those examples are the extreme on one side of purely personal. Where we have a blurring is what if we have a relationship that exists between a county official and another county official, or employee and employee. That relationship exists independent of their status as co-employees or co-officials with the county. So you're going to have a mix. You're going to have communications that relate to county business. You're going to have communications that don't relate to county business. You're going to have communications that relate to both. What do you do in that circumstance? And that's, again, where it gets incredibly challenging, because it may be that some records contain information that is related to official duties, which you have to disclose, and information unrelated to official duties, which you don't have to disclose, which means we have to redact certain information. Who does the redacting? Well, it's probably going to fall on corporation counsel to make sure that we are complying with the public records law to tell you what needs to be redacted. All that means is it's time consuming and it's expensive. And so again, the public understands what the public records law obligations are. We've seen the public and certain lawyers within the public outside of county government weaponize the public records law. And I'm telling you right now, there's not a darn thing we can do about it. We still have an obligation under the law to respond to records requests. It doesn't matter what the motive of the requester is. It doesn't matter if we think that they're weaponizing the public records law. We have an obligation to respond. So, what communications are not purely personal? Text messages between board members during a board or committee meeting. We saw this come up with the Madison City Council. They were embarrassed a few years back where there were actually text messages going back and forth between the council members during a meeting. A reporter made a public records request for those text messages. You might ask, how is it that the reporter knew that there was texting going on between those council members during the meeting? Well, because every time an item of business came up, all of a sudden, you could see the council members picking up their phone and doing this sort of thing, and then putting the phone back down, and then voting or discussing or whatever the case may be. The public sees that. The press sees that. And if they see that during a meeting, they're going to make a records request for what was going on that particular council member or supervisor's phone during that meeting. So let's avoid that. I would love to see a board rule that says you can't use your electronic device during a meeting without permission of the board chair. If you're going to use a device, you're going to use the county issued iPad or whatever electronic device that the county issued for purposes of providing you with the agenda and the board meeting packets, if that's what you do in your county, but you're not going to allow supervisors to get on their phone during these meetings. That way we don't have this issue. We don't become extremely embarrassed. Encrypted messages of any type that are sent out by state employees. That was a case in Michigan. Or elected officials. That was a case in Colorado. If they're encrypted, that encryption process creates a public record because it's going through the county system. Be careful of that. I don't necessarily think that every single encrypted message is going to be a record, but understand that in other states, they've encountered this issue and found that. General communications with friends or family that do not relate to official duties. Again, if they don't relate to your official duties, they're going to be exempt from disclosure. Content that relates to official functions or responsibilities may qualify as purely personal depending on the circumstances. Don't rely on that. Don't make judgment calls on your own. Speak with corporation counsel on this issue. It's going to be incredibly important. Private accounts, just because it's going to your Gmail account or your Yahoo account does not mean that it's not a public record. You can still conduct county business on those accounts, all right? So understand that if you are soliciting input from citizens on those email accounts, the input that the citizens provide you on matters of official county business are going to be records under the public records law, and they will have to be disclosed, which is why I always tell counties to have within their board rules or ordinances or both, that there is to be no official communication on anything other than your county issued email address. Number one, it avoids confusion and problems under the public records law. But number two, it allows IT to maintain those records in a storage system so that we can search them, so we can produce them when a records request comes in. And so we have storage for an adequate period of time to meet our obligations under the public records law as it relates to retention of those records, okay? Again, the content determines whether something's a record, not where it's stored. Here's some guidance that the Attorney General provided in July of 2010. It's dated, but it is still relevant today. This guidance came out after we had a plurality decision in the Schill versus Wisconsin Rapids School District case. That case came out in the late 2000s. I can't recall exactly what year. It might have been 08 or 2010. Attorney General said, okay, how do we deal with this? You might remember just a moment ago, I called it a plurality decision, meaning that there were enough justices that agreed on a certain point to make it binding precedent, but there was not a majority opinion across the board that said, yes, these are public records. No, these aren't public records. Essentially, that leads us to that whole point of how purely personal emails are not, they're not completely excluded from public records, but they are an exception. And that's why. It's because we have a plurality decision in the Schill case, all right? This guidance from the Attorney General in 2010, I think it's important to hear, to have it in full so that you have an understanding of the way that the Department of Justice and the Attorney General looks at this issue. Again, right there in the middle, we say the purely personal email exception to disclosure should be narrowly applied. If there's any aspect of the email that may shed light on governmental functions and responsibilities, that relevant content has to be released. If a document contains both personal and non-personal content, we have to redact the personal content and otherwise produce the official content. Individuals who are concerned about the misuse of public resources, personal use of government email should not be deterred from making records requests that might reveal that misuse, all right? So again, even if somebody wants to know, I want to see all the emails that Bill Smith sent from that county computer over the course of the last 6 weeks, we have an obligation to at least see how many emails are there. And if we say there are a lot of personal emails, we're not going to disclose them, requester has an opportunity to determine, well, does the 30,312 emails constitute a misuse of public resources? Because if there's 30,000 personal emails being sent out on a county computer, that's misuse. That's a lot of public resources going to your personal life. Yes, they have an opportunity to get that information, all right? And this is the last part, the last sentence here that I find troubling, because it gets back to that whole notion of, well, what do we do if we have a question about whether it violates county policy or evinces a violation? If an individual has made a request and has a reasonable belief to say that the emails that are being withheld because they're purely personal might evince a violation of policy or law, they commence a legal action, come out, release, and ask the judge to look in chambers, in camera, outside of court, review those disputed emails to make a determination. That's an incredibly time-consuming and expensive process. Pain in the butt. So again, my preference would be, again, official computer, official phone, official business. Personal computer, personal phone, personal business. Create that separation. Understand that as soon as you blur that separation, you're opening the door to all sorts of potential problems under the public records law. All right, board members have to cooperate in preservation and disclosure. Understand that the definition of authority under the public records law includes a public official such as a county board supervisor. So each county board supervisor is responsible individually for his or her records created, all right? That doesn't mean that we can't have policy, whether it be in board rules, ordinance, whatever, that tells board members exactly how they preserve and exactly what they do in the event that a records request comes in. I've had situations where a requester will send 26 different records requests out to the 26 different board supervisors, all the same request, but all sent out to all of the individual supervisors. Under the law, those individual supervisors have an individual duty to respond. Does that mean that each individual supervisor is left out there without a life preserver to respond as they see fit? No, No, just because they have an obligation under the law to disclose doesn't mean that we ought not have a process where we shepherd that information through the appropriate individual in county government to evaluate the request that comes in and evaluate the obligation to respond and what that response looks like. So if that happens in your county, make sure that you have a discussion with your corporation counsel, your administrator, your administrative coordinator, your county executive about how it is that we are going to respond as a county to this variety of requests that is with a shotgun approach that goes out to each individual county board member. The other issue that comes up relates to, before I go on to social media. Again, have something in your board rules, have some sort of policy out there that each supervisor signs to acknowledge their receipt and understanding of those rules, provide written guidance, conduct training with your board, other officials, other employees about public records law compliance. These are ways that you can ensure preservation and make sure that you're meeting your obligations under the public records law. I will say, before we get into social media, we have a couple of questions here from Natasha. The Employment Relations Committee is requesting a workshop reviewing internal data and developing action steps to promote. It's a follow-up to a request from the committee meeting. Does this need to be an open meeting? Natasha, I'm not going to say whether it is or is not, but what you have said is if the Employee Relations Committee has formed a work group, then that work group may be subject to open meetings depending upon what that Employee Relations Committee did. So I would encourage you to speak with Corporation Counsel to evaluate what it is that the Employee Relations Committee ordered, so to speak. All right, other questions. Lynn asks, as a county clerk, I occasionally have board members text me to say they're having issues getting in the Zoom meeting. They text me for help. Can this safely continue? Yes, on an issue like that, I think that can safely continue. Understand, Lynn, that if a request comes in for the text messages that you have received or sent to county board members, you may have to disclose screenshots of those text messages, but yes, you can continue with that. Kelly asks, campaign-related text between supervisors, discussion of candidate recruitment definitely should not be on a county device. Is that a public record? If it's related to the campaign, it's not a public record. A campaign is not an official function of county government, and so I don't view that as a public record. So again, definitely shouldn't be on a county device, even if it's on a personal device. If somebody is asking for campaign-related information, that's purely personal information. All right. Social media, this is where we get into some hot water a lot of times because social media is, again, a very easy way to broadcast a very, very quick message out to the public in a very, very quick manner. And so information posted by county departments to social media sites is going to be a public record. Not just likely, it's going to be a public record. It has to be retained according to the retention schedule. What is the rule on the retention schedule? And this is what drives me nuts, is that we know that the Public Records Board adopts schedules and that we as counties adopt those schedules as our own. What is the rule on social media sites? There isn't one. The Public Records Board has not developed a specific rule relating to social media. So we don't know what the retention period has to be. So my question out there, and I don't know the answer to this, my question is, have counties adopted retention schedules related to social media sites? And if so, what are those retention schedules? I think that's a discussion we ought to have statewide amongst all of our counties about what we're going to do to retain the records associated with social media. Now, we know that with county-run sites, a county Facebook page, a sheriff's office Facebook page, a human services department, Twitter page, whatever, an official page, that's going to be subject to disclosure under the public records law. But what happens if we have an elected official or a county employee running their own site? What if they run their own social media site? And what happens if they blend their personal life with their official life on that social media site? Is that blend going to create problems? You bet it is. Absolutely it is. It's going to create problems under the First Amendment, which we talked about in a different discussion in the boardroom, but it's also going to present public records issues because how much of that social media site is going to be open to public inspection as a result of posts on that social media site relating to official county business? The answer is a heck of a lot of it. So How easy is it to retain all of the information that is put onto that social media site if it relates to an official function? That's not going to be easy, all right? So again, understand that the utilization of social media is going to create a public record. It's going to. How we deal with that is going to be more difficult. So in looking at this, even the personal posts that appear on a county page are going to be public records. So we have to figure out a way that we deal with this. We've got some guidance from the Public Records Board. Again, the Public Records Board has identified social media records that are going to create public records, okay? So we've got that guidance there. So what are the best practices that the Public Records Board has provided us? Okay, understand current policies, understand your government unit's current policies and procedures. That's all fine and good. I agree with that. I think that's awesome guidance. Do we have policies? Do we have procedures? What is it that we are telling our county officials? What is it that we're telling our staff? Again, is this an opportunity to be proactive as counties in developing these policies? 100%. We should absolutely be looking at developing policies and procedures related to social media utilization that even in part speaks to official functions within county government. So even if you have a personal page and on that personal page, you solicit feedback on an issue relating to the official function of county government, we ought to have a policy on that. Records retention policy, and I'm not going to get into it today, but a policy related to when we speak on behalf of the county on matters of county concern. All right. Identify public records and platforms. Identify what communication tools are going to be okay and what's out of bounds. We ought to have official channels for official county business. And we ought to demand of our officials, employees, that it's fine that you have your own individual Facebook page. It's fine even if your campaign has a Facebook page, but I want prominent on that Facebook page that this is not an official Facebook page of Phillips County government. You got to make sure that that happens to make sure that we don't give the public the appearance that this particular person is communicating official county business through their personal platform. Clarify who the custodian of that content on the social media page is going to be. Remember, I spoke to working hand in glove with your IT department as it relates to retention of emails and text messages. Same with social media. What is the best way to make sure that we preserve the content on those social media sites to ensure that we have the ability to respond to a public records request? Because again, the only thing worse than going into court and telling the judge that your supervisor got rid of their phone is to say, we destroyed a public record. Sorry, judge. That does not look good. So what's the best way to make sure that we don't go into court and have that statement on the record? Work with our IT department to understand retention, to understand production, to understand protocols associated with retention and production, and then have a policy and procedure document in place to ensure that we carry out and fulfill our responsibility. Training, that's incredibly important. And I know that we are focused on training right now because we have elections coming up next week and we have new county boards that are coming in and we have orientation. That's a great opportunity to have training on that. But does it stop with that orientation? No, that should continue throughout the year. There ought to be consistent updates and training to make sure that everybody is on the same page. Monitor usage and monitor the landscape. Those are very important points as well. Michael asked a question. To simply listen to yourself as a county board supervisor on your personal social media account, open the door to a records request, even if you do not conduct county business from that account. Absolutely, Michael. That opens you up to a request. Whether you have records on that personal account that constitute public records is a completely separate question. There is nothing that would stop somebody from asking you to provide all records maintained on that platform. Nothing stopping anybody from asking that question. But if all of the records on that platform are unrelated to county business, can you say that that is a personal account and there's no county business or no record contained within that particular social media account? Absolutely, that can be a response. But again, I would love to have a policy in your county that speaks to that. I would love to have a procedure in your county that speaks to what you do when a request comes in like that. And I would love for you to speak with your corporation counsel about how to institute those policies and procedures. All right. Before I said that the Public Records Board has not come up with a retention schedule as it relates to social media accounts, there are statutes that speak to the general obligation to retain public records. Under 19.35 sub 5, we have an obligation when a request comes in not to destroy records that are subject to a request, even if we withhold production of those records. All right. So we have an obligation once a request comes in to make sure we set aside any records that may be responsive to that request. 59.52 sub 4 contains a laundry list of items with a retention period for certain records within county government. Excluded from that list is any mention of electronic records or social media accounts. 16.61 sub 3 says that the Public Records Board has the opportunity to define a minimum retention period for certain records in county government, and the Public Records Board has done that, but they have not done that as it relates to social media posts. And so we're operating right now a little bit in a gray area about what is the required retention period for these social media accounts. Again, I'd be interested in hearing from other counties if people have adopted retention schedules as it relates to social media, because I don't think there's uniformity out there. Then we get to this whole question of cost of storage. And this is a really difficult one because it would be really awesome if we had all of the cloud space in the world to store all of this information and it was free. It's not. There is an expense associated with storing these records. And I always encourage counties to take a look at the expense side of the equation. The reason I encourage counties to do that is that it is an awesome idea to both live stream your county board and committee meetings and record them videographically so that you can store them and they're always there. But guess what? That costs money. And guess what? Those videographic recordings are going to be subject to a public records request. And if somebody makes that request, you have to produce it. So again, think about the cost side of all of this. Work hand in glove with your IT department to understand all of these issues and then tailor your policy and procedures around those issues to make sure that you account for all of those costs. All right, we're going to get into very briefly some special considerations in the open meetings law. We've talked about the showers test. Here's where the issue comes in as it relates to electronic communications, social media sites, and so on. If you have a group of board supervisors that decide to start commenting on a Facebook posting, remember that that communication happens or can happen almost in real time. You're commenting, get a response, comment again, get a response. In other words, it's an almost a real-time conversation that's going on. The Attorney General has said that real-time conversation, even though it's not happening face-to-face or on a telephone, it's happening on a social media site, could be a walking quorum, okay? So again, I would encourage you heavily to avoid these real-time conversations happening on social media for fear of it creating a walking quorum. All right. Again, we have to look at the purpose. If you're going to debate the merits of the Packers letting Jones go and signing Josh Jacobs, you can have that debate as much as you want with any other county board member. It's unrelated to government business. But as soon as you start going into some issue that is either at the county board or will eventually be presented to the county board, you got a problem. So avoid that issue altogether. Key point, you have to remember that social media interactions provide an opportunity to have a walking quorum, and so we want to avoid that, okay? Same thing with text messages. Oftentimes, like I said before, what was happening in that Madison Common Council meeting where council members are texting back and forth, if the public sees you on your phone during a meeting, during a committee meeting, whatever, they're going to ask the question, send me all text messages. And as soon as you have to respond to that request and send them the text messages, they may see that you were texting not only during the meeting, but before the meeting. And so all of a sudden, you've got before the meeting, a text chain that involves 5 different supervisors that have agreed to act in a certain way, well, that's a walking quorum, and that's a problem if those 5 members could somehow influence the board vote or the committee vote. So again, avoid having that issue crop up. Don't text back and forth about county business. It's okay to send a text message to say, hey, do we still have a meeting tonight? Because the weather's pretty ugly outside. And the response is, yes, meeting is still set for 7 p.m. at the courthouse. That's okay. There's no problem with any of that. But as soon as you start saying, hey, are we having the meeting tonight? It's an important issue. Remember, we're going to vote on that budget amendment. I think I'm going to vote no. What are your thoughts? That's a huge problem. So avoid those discussions, whether it be through social media or text. Again, from the Attorney General, where the Attorney General, just like me, just like Corporation Counsel and others, is struggling with the application of the open meetings law to these laws that were written prior to the advent of technology. Okay, no Wisconsin court has applied the open meetings law to these kinds of electronic communications. All right, but we have the ability to take a look at the law and say, how is the law going to apply to this new technology? And we think that there are significant concerns under walking quorum, negative quorum, and other issues such that we should avoid the use of that type of communication to conduct county business. So it's easy for me to sit here and say, don't do it. I know it's going to happen because I know we're all human beings, but you need to limit it as much as possible. All right, we have, again, with the social media, the application to that. Closed sessions. I just want to touch on this briefly because this has come up recently. There are exceptions in the law that allow you as a board or a committee to convene in closed session and to remove other members of the public from the discussion because you want to maintain that particular discussion in confidence. We've got 1B, 1C, 1E, 1G, all of this. This has come up, I think, recently, at least as far as I've seen, where the discussion in closed session goes beyond what's contained on the agenda. Avoid that. Cut that off and stop that immediately to the extent that you can. Understand that each supervisor that is in that closed session has an independent obligation to make sure that he or she does not violate the open meetings law because they bear individual responsibility for that particular closed session under the law. So it's your obligation as a supervisor, if you're a supervisor, to make sure that that discussion in closed session sticks to what is contained on the agenda for closed session. Also, I've seen 1G come up, and that's conferring with legal counsel. It's not simply having an attorney in the room. It's having an attorney in the room for the purpose of engaging in a discussion about a legal situation that the county's involved in or is likely to become involved. Okay, so make sure that just because you have an attorney in the room doesn't mean you have the opportunity to discuss whatever. That discussion under 1G has to relate to a claim or strategy that you're going to adopt in relation to that claim or pending claim. So you have to make sure that that's covered in closed session. Your agenda language is key. You've got to make sure that you cite not only the exception, but also the reason that you're going into closed session. So again, we're nearing the end of this discussion here. A couple of points here that I want to take a look at that have come in. All right, Kelly asks, a person contacts you on your personal page and asks a county-related question. What are your options? If you tell them it's a personal page and direct them to please contact you via your official county contact points, have you just created a public record? I don't think so. I think if you respond and say, no, all information related to county business has to be directed to me over here, whether that be an email address or a separate web page or whatever, I think that's fine. And that has not created a public record. All right. Because again, you're not communicating about official county business. If a record is available on the county or another public website, can you direct the requester to the document with a link, like a board meeting agenda or a recording of a meeting that's on YouTube? Yes, absolutely. You can do that, Mary. I think that doing that is a perfectly legitimate response to that type of inquiry that comes onto your personal page. Again, I don't have any attorney general guidance or court guidance that I am pointing to here, but if I go to court, and I want to think about this, if I go to court in defending Mary in this circumstance, and the requester says, well, wait a second, the record where Mary directed me to the other record, that in and of itself is a record that had to be disclosed. And once that record is disclosed, it shows that that particular personal site was used for county business. Therefore, I want to take a look at everything maintained on that site. I like my chances if I say, Judge, Mary made it very clear that the information that this requester was seeking was available over on this county website. I think a judge is likely to agree with me on that. I think the judge is likely to look at the requester and say, what more could you want from Mary in this circumstance? And so I like my chances on that one. I got a question from Brad in Washington County. What might constitute a tacit agreement in my experience? That's a great one, Brad, because we know that with walking quorums, the definition of a walking quorum is a group of supervisors that agree expressly or tacitly to a course of action. And so what does tacitly mean in that circumstance? And as an aside, I still am waiting for somebody to provide me with the distinction and definition between a walking quorum and politics. That they're the same thing in my estimation. But that aside from what is a tacit agreement? I mean, I think it's the whole wink and nod thing, where you can evince some sort of intent within those text messages or those email communications or within those social media posts, the wink and the nod that we're going to act in a certain way. And I think it depends upon context and circumstances. And so I think that the word tacit is incapable of objective definition there, but I think we have to look at the surrounding circumstances, take a look at everything that led up to those particular communications and say, you know what, as a result of those communications, are we acting in a way that shows that we are acting uniformly? That's what I think tacit agreement might say, but I don't think that's easy. I don't think that's an easy one. And I don't think the courts, I know the courts haven't come up with a good definition of what is a tacit agreement. All right, I have been talking an awful lot for the past hour. I certainly appreciate everybody's attention, and I hope you can understand that we grapple with these issues. We, me, Corporation Counsel, others, we grapple with these issues significantly. They're not easy, and so hopefully that has come through here, which again just leads me to the advice that I've said throughout this discussion. Talk with your Corporation Counsel early and often on these issues, and really have an honest discussion about how can we create policies and procedures that are going to allow for some uniformity in how we treat these issues. I really think that that's a really good idea. I'll leave this open for another couple of minutes and see if we have additional questions come in. Thank you, Mark and Mary, for your kind words. Anybody else who wants to post kind words here, feel free to do so. I don't see any other additional questions. So Sarah, I know you're not coming on camera and you're not coming off of mute, but we do not have, I see a couple of thank yous. Thank you, everybody. We do not have any other questions. So what I am going to do at this point is stop sharing, and we are going to end this discussion for now, and we can pick this discussion up later after you've had an opportunity to digest. So thank you all for your participation. As a reminder, there is no In the Boardroom in April. We are going to allow everybody to focus on elections and organizational meetings, and we're going to pick back up in May, where right now, tentatively, we have planned what I find to be a fascinating topic, and that is county organization. I want to talk about the role of elected officials, the role of constitutional officers, the role of department heads, role of administration, and it's going to be a little different than our typical roles and responsibilities discussion. We're going to delve a little bit deeper into the county organizational chart. So with that, I will end for today. Wish everybody a happy holiday weekend and see everybody back here in May. Thank you.